A, a 28-year-old man, and B, a 27-year-old woman, were in a romantic relationship and were living together. After being in a relationship for nearly 3 years, A asked B whether they could have sexual intercourse. B said that she would consent to sexual intercourse only if A agreed to marry her. So there is a clear condition from B. She would give consent only if A agreed to marry her. The next part is A promised to marry B, and thereafter they had sexual intercourse multiple times over the next 3 years. So they were living together, they had regular sexual intercourse for the next 3 years. Subsequently, B discovered that A was not being faithful to her and was in a relationship with another woman. She broke off the relationship and sought to initiate criminal proceedings against A. Which of the following offenses can A be prosecuted for? Cheating, criminal breach of trust, custodial rape, adultery. Now going by the process of elimination first, adultery is ruled out. Why? Anyone can tell me? Why should we rule out adultery? Yes, Smita, you can switch on your audio also, or you can type it out. It's not a marriage, that's what Shruti says, but yes, for adultery, what is required? Yes, the correct answer is the offense of adultery has been struck down. It is no more an offense. It has been held to be unconstitutional by the Supreme Court, and therefore we can straight away rule it out. Even otherwise, adultery will be committed only if a man has sexual intercourse outside marriage with another woman who is married. The other woman should be also married. Sexual intercourse outside the marriage with another woman who herself is married, then only it will be adultery. We are not given whether the other woman with whom the husband had relationship was married or not. So we cannot really find out whether it is adultery or not from the facts given in the question. Custodial rape, of course, there is no custody and therefore it can't be custodial rape. So this option C is also ruled out. Criminal breach of trust, that obviously cannot be the answer because it relates to some property. When you entrust some property to another person, then only criminal breach of trust may take place if other conditions are satisfied. So by the process of elimination, the answer is A, cheating. If B is able to prove that A never had the intention of marrying her. So when A made the promise, did he have the intention to marry B or not? That is a central question. If A is able to show that, if B is able to show that A never had the intention of marrying her even when he first made the promise, then only it will become cheating. If initially A had the intention of marrying when he made the promise, and thereafter 3 years or whatever period, if he had a relationship with another woman, etc., then this offense will not be established. As far as our question is concerned, the answer is option A. Yes, how can we call it cheating? I have given here section 415. whoever by deceiving any person intentionally induces the person deceived to do a thing which he would not do if not deceived, which act causes harm to that person in body, mind, reputation or property is said to cheat. In this slide, I have given only the relevant portion of the overall definition of the offense of cheating. That definition covers so many aspects, mainly delivery of property. Here we are not concerned with delivery of property because no property has been delivered by the deceived party. Deceiving is there if the promise was false, and then she was made to do a thing which she would not otherwise do. So that point has to be kept in mind, that she gave the consent for sexual intercourse only because there was a promise. She would not have given the consent if there were no promise. And this consent which she gave, because of which the sexual intercourse took place, whether this act causes harm to that person. Which person? The person who gave the consent. That is the lady. Does it cause any harm to her? The harm can be in body, mind, reputation or property. No property is involved here, of course. No reputation is also involved. But there is harm to her in mind. She is disturbed. She is agonized. And we can say that the act of sexual intercourse has caused harm to her in mind, and therefore it can come within the ambit of the definition given in section 415. If there is deceiving, the starting point for this definition is deceit. And what is deceit? A false promise is a deceit. So if the promise was false, that is, if the man had no intention from the very beginning to enter into marriage, then of course the consent obtained by him was by deceit, and it will fall within the definition of section 415.